Turn to the fifth case on this morning's docket. That is case number 114542 in the matter of Benjamin Cassad.
May it please the court, excuse me, counsel. Mr. Chief Justice, I'd like to reserve 3 minutes for rebuttal, please.
3 minutes is granted.
Thank you. I'm Deborah Hughes, Deputy Disciplinary Administrator here on behalf of the Disciplinary Administrator's Office. This is an original action involving attorney discipline. This case is before the court after having been before a hearing panel of the Board of Discipline. It was heard on September 1st, 2015. The respondent, Mr. Cassad, signed a stipulation to the facts that were alleged in the complaint and to all of the rules violations that were alleged in the formal complaint. The rules violations that were alleged and that were stipulated to are KRPC 1.1 competence, 1.3 diligence, 1.4 communication, and 8.4D, which is misconduct prejudicial to the administration of justice. The basic facts in this case, I won't go into tremendous detail, but Mr. Cassad represented an individual named R.B. Mr. B was convicted in Leavenworth County of 3 counts, 2 felony counts and a misdemeanor count. The felony count was forgery, a severity level 8, and he was sentenced on that count to 10 months. The middle level count was a felony, and it was conspiracy to commit forgery. He was sentenced to 6 months on that. It was a severity level 10, and the misdemeanor theft was a 12 months in jail sentence, all ordered to run concurrent to that top charge, which was the 10-month sentence. Mr. Cassad was appointed to represent Mr. B on appeal because he was an indigent defendant. Mr. Cassad filed a brief with the Court of Appeals. In that brief, Mr. Cassad raised several issues, including that Mr. B's right to statutory speedy trial had been violated. The state filed its response brief, and it conceded the speedy trial issue on 2 of the 3 counts. It conceded the issue on the top charge, and it conceded it on the misdemeanor charge. It did not concede it on the middle charge. After the state filed its brief, the case was set for summary calendar by the Court of Appeals, and then the Court of Appeals issued a show cause order to Mr. Cassad that his brief failed to comply with Supreme Court Rule 6.02 in that he failed to cite to the record on appeal sufficiently in his statement of facts, and ordered him to file a corrected brief. Ordered him to submit a corrected brief within a certain period of time. I think it was about 2 weeks period of time. Mr. Cassad failed to do that, and about 3 to 4 weeks later, the Court of Appeals issued an order dismissing Mr. B's appeal. Mr. Cassad did nothing, and the Court of Appeals appellate court clerk issued a mandate to the district court dismissing the appeal, which essentially affirmed all of the convictions. Mr. Cassad had no contact with his client at any point throughout the entire appeal. He never contacted him about the filing of the initial brief, never sent him the copy of the brief, never sent him the state's brief, never notified him of the summary calendar setting, never notified him of the show cause order, and certainly never notified him that his appeal had been dismissed. It was learned about by Mr. B's trial counsel, who was interested in the case and was following up on it because his client was on probation. And he checked the status of the docket or the appellate case by looking online and found out that the appeal had been dismissed, and he contacted Mr. Cassad, who then told him, well, I'm following up on that. I'm going to take some type of corrective action. Ultimately, Mr. Cassad did file a motion to recall the mandate, which was unsuccessful. Mr. Cassad self-reported, and that's how the complaint ended up in our office, and we pursued it. Based on the stipulations and exhibits, the hearing panel did find that the respondent violated all of the rules that were alleged in the complaint, 1.1, 1.3, 1.4, and 8.4D. Mr. Cassad did not file exceptions to the final hearing report. to the findings and conclusions. So the issue today before the court is what is the appropriate discipline. At the hearing, my recommendation before the hearing panel was for published censure with specific conditions, with a little bit of twist there. I requested.
How does that work?
How does that work? Either how is it allowed or how functionally do we do that?
Both.
It's allowed under Supreme Court Rule 203A5, which says that misconduct shall be grounds for, and then 5 is any other form of discipline or conditions separate from or connected to any type of discipline stated above, whether or not recommended by a hearing panel, which the Supreme Court deems appropriate. So that's pretty broad. And then this court has in the past imposed published censure with conditions in several cases. And those type of conditions are similar to what I requested and what the hearing panel recommended in this case, a form of less than supervision. And I would specifically refer the court to in the matter of Lee, which is a 2008 case, 287 Can 676 2008. The hearing panel made the recommendation to publish censure subject to conditions where the respondent continued to participate in psychological treatment, provide quarterly reports to the disciplinary administrator for a 2-year period of time, comply with the annual registration, and directed the disciplinary administrator's office to file a motion to show cause in the event the respondent fails to comply, and request that, and directing our office to request that he be suspended for 1 year if he fails to comply. And the court, in its opinion, adopted those recommendations. That's one example of the court having done that. So I think that's available to the court.
But you said there's no supervision, but who's going to determine the second comply with KLAP agreement, which should be extended to a total of 3 years? If there's no one supervising, how do we know?
Well, there's supervision in the sense that KLAP would contact our office during this 3-year period of time in the event that they're notified by his monitor, because he's under a monitoring agreement. KLAP would notify
and then
our office.
they notify you that he's violated the agreement,
Right.
and then what happens then?
We would file a show cause order like the court did, like the court directed in the Lee case. We would file a show cause order with this court, and depending upon what the violation was, we would ask the court to reconsider its...
Well, I know, but Mr. Cassad says, no, I didn't violate the agreement.
Yeah.
So we have you anticipate we would have an evidentiary hearing before this court to determine whether he'd violated?
I imagine that the court would have the power to direct that there be a hearing on that issue.
And I noticed one of them is give releases to the disciplinary administrator to get reports from treatment providers. That sort of indicates to me that there's the possibility of ongoing supervision by the disciplinary administrator. And I guess my question is, it all looks to me like a suspension or probation or what, something other than a public censure that usually you would think, okay, you go forth and do this no more, rather than set up on a 3-year supervisory scenario. And I'm just asking why not have a suspended suspension up front rather than have a de facto probation and then deal with it on the back end. You understand what I'm asking?
I do, and we thought about that in the office, and what if you have an offense or misconduct that doesn't rise to the level of suspension? It's not a suspension type of offense, and it is a published censure offense, in our opinion, if we say that. if that's our starting point. But we believe that the respondent would benefit from the KLAP provisions that are in the monitoring agreement. And we want to encourage that. This is a way to do it, and there was precedent for it, and the rules provide for it, so we requested it. Is it workable? Does it fit nicely into some category? It's not probation. It's not the type of probation that we have under suspension. It's not as strict as that. We don't have a typical probation supervisor, but it is some form of lesser supervision. That's all I can say. It is something, it does impose a form of supervision on our office that isn't ordinarily there other than in a supervision, but it's for a lesser form of offense that doesn't rise to the level of where we want to ask for suspension. But it gives us something over the respondent. So we would ask in this case that, we're asking for the court to adopt the recommendation. It's continues to be our recommendation. I do join in the panel's recommendation. I had asked at the hearing that it be for the 1-year period of the KLAP monitoring agreement. The hearing panel and the respondent had asked that the period extend to 3 years, the KLAP monitoring agreement, and I agree with that. It's my understanding that Mr. Cassad has already complied with one of the recommendations, and that is he has obtained a physical examination within 30 days. I've spoken with KLAP, and he has been complying well with the terms of the monitoring agreement and is doing very well. So I have every reason to believe that the recommendation is appropriate, and I ask the court to adopt it today and to adopt the findings and conclusions of the hearing panel.
I need to clarify the 1 year, 3 year.
Yes.
What are you asking for? That we just have the 1 year?
The 3 years.
The 3 years, okay.
Yes.
So you'd like us to adopt the panel's recommendations?
Yes, that's correct.
All right. Any further questions? Thank you, counsel.
John Ambrosio on behalf of the respondent. Mr. Chief Justice, Your Honors, may it please the court. We agree to all the facts that were found by the panel and the violations that are indicated in that report. We agree to the recommendation of public censure recommended by the panel. It was at my suggestion that the panel indicated that they wanted this agreement with KLAP to be 3 years as opposed to 1. Although I'm not an expert and KLAP thought 1 year was enough, to deal with depression, to deal with alcoholism, to deal with anxiety, you can't do it in just 1 year. Hence, I suggest, and the panel agreed, and my colleague agreed, that this would be a 3-year agreement. This is an ongoing process for this. Well, he's 59 years of age.
Did KLAP agree? I mean, I only asked that because you just said they wanted it to be 1 year. So that occurs to me that we've got a party to an agreement, and I'm curious, did they agree to 3 years?
The answer to that is, did I ever call them? No, I didn't, but I think they'll go along.
Well, I do too.
I think they're great people.
They're very helpful, and
They're
they are
terrific.
great people. But we're talking about an agreement, and you just told me that, in their opinion, 1 year was sufficient. And I am a little bit leery of imposing an additional 2 years on a party that says it's not needed. I mean, that actually could be counterproductive. It could take resources away from others who may need it. I'm not questioning what happened. That just caused me to think that this seems a little strange to me.
I think my job is sometimes to make sure that none of the public is protected, that my client has the boundaries that are necessary in order to succeed. So that's why I suggested it. I'll take the blame for not calling KLAP ahead of time, although I bet $100, if I had $100 in my pocket, that they would right away go along.
I have no doubt you're right. I'm just, I can
hear
see
you.
some concerns with not hearing from them on that fact.
I hear you on that, Your Honor. This man has done...
Plus the asset allocation part of that is if KLAP has finite resources.
True, absolutely,
Yeah.
absolutely. You're right. We don't have enough people to supervise. We don't have enough monitors. We've got people like myself who do it, who aren't alcoholic or drug users, just because we need lawyers to help these people. I agree with you. We need more people involved. He has done the physical. He's got a clean bill of health. He is going to the resiliency group. He is on medication, and he is in therapy. And he is doing everything that's necessary for him to make sure that this doesn't happen again. The more I work with people who are depressed, the less I understand what it is. Because I know you're saying to yourself as you read this, how did he not do what he was supposed to when he received an order from the court? And all I can say is, depression is awful, and now that he's dealing with it, and now that he's on medication, this will not happen again. It was like his feet were in the mud when he got the order from the court. His anxiety and depression stopped him from being able to answer that call from the court. He is doing everything. He's on his way to recovery. He's working very, very hard. This is a man who's going to be 59 in a couple of weeks. He has never had any prior problems before. And he worked on his alcoholism for almost 9 years, but had never worked on his depression because that was just found out. Without further ado, my client would like, with your permission, to address you.
May it please the court. When these events first happened, I found myself embroiled in a situation that rapidly got out of control. Hindsight being better than foresight, of course, I should have asked the court initially to appoint another attorney to handle this matter. Obviously, I should have completed the revised brief in time or asked the Court of Appeals for additional time to complete the revised brief. If I had just done that, we probably wouldn't even be here today. Each wrong decision I made the situation more difficult and unmanageable. I did not understand the extent to which depression and a sense of hopelessness and being overwhelmed could cause me to lose perspective of the most important thing, my client's interests. I very much regret that I did not do the things I should have. I would like to apologize to him. I would also like to apologize to the court. I recognize that it's my fault that we're here today. Since this unfortunate event happened, I have taken considerable steps to ensure that I never have a lapse of judgment like this in the future. I followed all the panel recommendations regarding the steps that I should take. I've seen the doctor, I've been taking appropriate medications, I've met regularly with my monitor, the resiliency group, and my therapist. I'm very grateful that these resources are available to assist me in maintaining a proper perspective of my responsibilities as an attorney. I would like to thank Ms. Hughes and the Disciplinary Administrator's Office for their recommendation in this matter. I would also like to thank trial counsel for helping me ensure that I did everything I could to keep this matter on track. I would also like to thank the members of the bar who wrote letters of support on my behalf. I would also like to thank my attorney for his help in supporting this matter. Most of my career as an attorney so far has involved working with indigent people in criminal or child in need of care proceedings. I can honestly and in good conscience say that the positive impact, assistance, and aid I've been able to provide them far outweighs the negative impact of this error. I respectfully request that I be allowed to continue to practice. This disciplinary process has been helpful in putting things in perspective and convincing me that I definitely do not want to be back here again for this kind of hearing. The plan as outlined in the panel report is a reasonable one and one that will be sufficient to ensure that I stay on track. I'm very determined to make sure that I never have an instance like this one happen in the future. Thank you very much.
Counsel, just so I'm clear, the three of you are all in agreement with the panel's recommendations on discipline, is that right?
Absolutely.
Yes, sir.
Very well, thank you. Any further questions? Thank you.
Just to address the one issue on the contract on the KLAP monitoring agreement, it is in the exhibits, the respondent's exhibit I believe it is, and it does leave a little bit of an open end for the agreement term to be extended. It says that the agreement continues in force and effect from its effective date through August 2016 or until the end of the monitoring period, and it does allow for it to be modified, amended, as to reflect any additional requirements set out in my therapy and/or the pending disciplinary case. So I think they do anticipate that. Now, that doesn't answer the question of resources, of course, but I think it's anticipated that it could be amended.
It sounds to me like it's anticipated it could be amended at the recommendation of KLAP. I'm just concerned that we're going to order, or we could order something that KLAP looks at and says, why did they do that? We didn't think that was necessary. And in fact, that may impede our work and our allocation of resources elsewhere. And that may not be the case. I could certainly see them saying 3 years is just fine. I just don't know that. Can you help me with that?
No, I can't, and KLAP didn't testify at the hearing, so I don't have any evidence to provide on that.
Any further presentation?
I do not have any, thank you.
Any more questions? All right, thank you, counsel. We thank you all for your arguments this morning. Court will take this matter under advisement.